Before 1st of May, when agents were able to serve Section 21 notices, they were comfortable with that. They've been doing that for many years. A lot of agents avoided Section 8 notices because it's not as straightforward as a Section 21, but we know now in the new world, Section 8 notice is the only notice that can be used if a landlord requires possession of the property. It's not just a case anymore of downloading that notice off the government site and completing that. You need to prove grounds for possession. So with ourselves, we're specialists in this area. You know, we do this 24/7. We know exactly what evidence is needed for each ground. We know the different notice periods, and we know if your tenant fails to vacate off the back of that notice, we know what the court are looking for. So we will ensure that that case is fully compliant from the offset. So as part of our service, you'll have access to our portal, which is 24/7. You'll also be assigned a case handler, so that's a dedicated point of contact who you'll be able to contact via email or directly over the phone if you have any questions, need any reassurance or need any updates on the case. If a letting agent or a landlord does go ahead and serve the Section 8 notice themselves and they get that wrong, it isn't just a case anymore of the case being dismissed at court and starting over. They could be liable for financial penalties, in some cases up to £40,000. So it isn't worth taking that risk. And for the sake of using a company like ourselves who specialise for a fixed fee cost, which we are very transparent about from the offset, you know, it's worth using us, making that payment, because it could become costly if things do go wrong later down the line by doing that yourself.